Your Honor, calling the case Daniel Saul versus People State of Michigan, case for 09DA911AR.
Good afternoon, Your Honor. Jim Amberg on behalf of Mr. Saul.
Good afternoon, John Pellis, Assistant Prosecuting Attorney on behalf of the people.
Your Honor, today is the date and time set for our appeal. I guess you could call it the second appeal in this ongoing case. Certainly I submitted a brief and we got to stay a sentence. I know the court's aware of what happened and Judge Nicholson not following your previous order. With all respect to Mr. Pellis and the people in this case, I received this brief literally 2 days ago, their appellant brief. And I'm not the guy, I'm like the last guy that would ever complain about that.
I okayed it too.
But
I okayed them filing it on Monday.
But the problem was I just never really, and like I said, I'm the last person I would ever be a stickler about the rules, but I just didn't have a chance to answer it because I'm so swamped with other stuff. And so I'm going to try to answer it as best I can by just my thoughts. And so here's what I think about their brief. The first issue is the issue of appeal as of right. Certainly, Your Honor, could take this by leave. As an appeal of right, I think we're still under the powers of the original appeal. This case is under the original appellate case. And this isn't like some new issue happened. Your Honor was very specific in your order. This isn't anything theoretical. There it was. You said that Mr. Sowell can't get WWAM Weekends. And so I do think we have an appeal of right for that reason, but I just didn't have time to brief it, and I'd have to go look at case law and everything else. So that's, as to their first argument, I would say that we do have an appeal of right. If not, certainly I think this case, it's up to Your Honor, but it would warrant leave given the very unique circumstances of it. As to the meat and potatoes of the people's response, which is the second argument, I tried to write it down, and it looks like there's three separate arguments that they make. The first argument is that the law of the case doesn't apply in this case. And what the people have done is they've claimed that they were not a party in the original action, so therefore they never had a chance to litigate this. Now, I respect the people's position on that, but here's my problem with that. First, they tried the case down at the district court level, so at that point in time they were a part of the case. They never sought any declaratory relief from the court up here, as would be custom in, I think, any civil case or even any criminal case. If you want to get out of the case, you need to file a declaratory action or something. They bypassed that and just said, Your Honor, well, we're not parties to this case, so we don't want to have anything to do with it. Well, without us arguing about that, I think they were still on the hook. Especially given the circumstances that they tried the case at the trial level. So, there's no law that I'm aware of that says that the people can just unilaterally pull themselves out of a case. So, a majority of their argument is, well, we never had a chance to litigate this. Well, wait a second, let's step back here. Oh, yeah, you had a chance to litigate it. You just chose not to. That's not my fault. I was here. Your Honor was here. We litigated this issue. The second part of their argument is that the first appeal was limited to the sole decision of whether or not the lower court illegally used their contempt powers. And obviously, Your Honor ruled that they did, but that wasn't what the appeal just was about. It was also about the sentencing. Now, when we're talking about a minor possession of alcohol sentence, the facts and the law are identical, whether or not it's a contempt of court or a probation violation. The sanctions for an MIP have to be the same because it's just a violation of the MIP statute. And the only thing that one can get if they violate the MIP statute is either what you could have got just without having probation or, some other stuff like you can get community service and fines and stuff like that. You can't go to jail. And certainly that's what we argued before, but it doesn't change just because it's now a probation violation. So, when we talk about that second issue of whether or not the original appeal was limited to just that decision of contempt, well, the people call what Your Honor's opinion was as far as the sentence goes with WWAM Weekends, they call that theoretical. And they get real legal and they call it obiter dicta, something I don't even know what that means. But I do know that I don't treat your opinion, Your Honor, as theoretical at all. I thought you were very clear in your order. And certainly, that's what we argued here, because that's what this is. This is not my original argument in Mr. Sowell's original appeal that came up here was that WWAM Weekends were not the community service that the legislature intended in saying that you can get community service for getting a minor possession of alcohol. WWAM is not that. Which brings me to the third argument of theirs, which the people basically say the facts before the court on the first appeal and the facts before Judge Nicholson when we were back down there at the probation violation hearing were not materially the same. And their reliance on this conjecture, and I'll call it that, is that Judge Nicholson tells us and I'm going to quote this, the true nature of the WWAM program. And so now I suppose that this supposed true nature of the WWAM program is presumed to be fact, which it's not. It's just Judge Nicholson's opinion, an opinion from a court where they call this WWAM program hard labor. They don't call it community service. They treat it as hard labor. And, Your Honor, although I don't feel as though we even need to litigate what WWAM actually is, I feel as though I want to. And I actually was going to put that in my original appeal up here, but I felt as though it wasn't necessary. But I will go through it. Judge Nicholson claims that WWAM is run by the county executive office, not community corrections. What I compare that to is saying that, well, Governor Granholm runs Jackson Prison. But you know what? It's not Governor Granholm slamming the door shut. It's MDOC. So just like with community corrections, they are the people in charge of all of this correction stuff. When you look at WWAM, here's what happens. And I actually brought a pamphlet that every unlucky young person that gets slammed with WWAM, and WWAM, which I would note has a picture of a hammer, WWAM and the WWAM thing, WWAM, right on the front it says Oakland County Community Corrections Division, right on it. When you open it up, you can kind of see what exactly the people are really in for. This is not community service where people are free to leave like Judge Nicholson would make us believe. That's not what's going on here. When these kids get there, first of all, you have to be either early or right on time, or else you don't even get to go in. And then guess what? You go to jail, because that's what the WWAM program is designed for. When you look not just at their pamphlet, but from Community Corrections' own little bench book on the different alternative sentences.
That's not my understanding. My understanding is if you don't show up or if you walk away, you're not sent to jail.
Well, not immediately, but the idea is, Your Honor, is that if you don't show up to WWAM, what they do, and this is what happens in the 52nd 3rd District Court. If, for instance, say Mr. Sowell did WWAM and he doesn't show up, or he shows up 1 minute late, they lock the door and they say, you can't come in. And then what happens is, then his, whatever they want to call it, but I'm going to say his probation is violated, and then he goes in there, and then what happens is that the judges will give him jail. And
But they can't give him jail.
Well,
because it's not a jailable offense.
Your Honor, you and I understand that. Unfortunately,
they would have to do what they were doing before, and that is hold him in contempt of court in order to give him jail.
Right.
They couldn't violate him and hold a violation of probation hearing and then find that he violated his probation and send him to jail.
And I'm glad to bring that up, Your Honor, because you and I are on the same page on this one. I believe that Your Honor is absolutely correct. It's what every other circuit court judge up here has held as well. But you can't tell Judge Nicholson that, because when you look at what she told my client when we were down here at the probation violation hearing, she tells him, I'm going to quote from the transcript. This is on page 4. It starts at line 14. She goes, the court, do you understand that the potential penalty for a finding that you have violated probation is possible revocation of probation along with possible jail time as well? So she's telling my client that he can go to jail for that, which we both know that that's not possible. So, you know, what Judge Nicholson tries to do here is not what the reality is. I mean, she's trying to spin this off that WWAM is some, you know, community service program, everybody's helping each other out. That's not what's going on here. I mean, what other community service program makes you pay $15 every time you show up and a money order paid to the Community Corrections Division? What other community service program will kick you out if you don't do everything precisely perfect? What community service program makes you take an alcohol test when you get there? I mean, this is not community service. This isn't going down to your church and helping out for the day, or going to the United Way, or going out in Meals on Wheels and helping out. That's not what the legislator intended. This is hard labor. This is much more akin to jail. What community service is supervised by guards, and you're transported by guards. And even Judge Nicholson glosses over that in her opinion, where she calls me a liar.